Good morning, Your Honors.
Good morning.
My name is Robert Tillman. I'm here on behalf of the appellant, Joan Walters, and I would like to reserve 2 minutes.
Thank you, John.
Your Honor, we're here today mostly because the defense in this case has taken the position that I've heard so many times in recent years, and that is that our new, relatively new, comparative fault statute has abolished any concept of joint and several liability, which is just plainly not true. In this case, we went to trial. We had 2 named defendants.
So, counsel, if I could fast forward a little bit to some of the issues. I want you to picture a hypothetical for me.
Okay.
And the hypothetical is this. I am the owner of a shopping mall, and I have on camera exactly these facts. I have hired a cleaning company to clean the floors on a regular basis of the mall because I need to make sure things are clear under both my statutory and common law obligations to have a reasonably safe environment and to make sure that I take care of any known hazards, including any known spills. My employee, while not on break, is taking a seat near the fountain in the middle of the mall. While one of the young teenagers who happens to be there, as a prank for one of his friends, throws down his Coca-Cola on the floor, causing a spill, right in front of my employee who sits there and does nothing about it for 3 or 4 minutes. In the meantime, Joe Smith, who happens to be shopping for suits that day, is walking by, slips on the Coca-Cola, falls, and breaks his spine. Joe Smith sues me as the mall owner, my janitorial company, for failing to clean up the spill despite it being in front of him or her, and the young teenager's parents, because obviously the teenager's not competent, who threw down the Coca-Cola for causing the incident. I want you to talk with me about who is what in that scenario.
Did your employee get sued as well?
Yes.
Okay.
Well, the janitorial company got sued.
Okay.
So the company, it's not my employee. So you have me as the landowner with a non-delegable duty there, correct?
Correct.
You have the janitorial company, who's my independent contractor, who has the same duties I do and is responsible, but I am ultimately on the hook for non-delegable duty.
Correct.
And then you have a joint tortfeasor there, someone who caused the spill, correct?
Correct.
Why is, and you would agree with me under that situation as you read the law, while mall company, my company, and the janitorial company would be on the hook jointly and severably for any damages to each other, both either contractually or as a common law indemnity between each other, the joint tortfeasor would be responsible for the teenager's own damages resulting, correct?
I'm sorry, the last question?
So the teenager, so it all goes to trial, the jury is asked who's responsible for what, the jury says 30%, 33% mall owner, 33% janitorial service, 33% young punk who threw the Coca-Cola down.
Gotcha.
You would agree, I think, that the mall owner jointly and severably is liable for 66%, that is his or her own and the janitorial company. And I'm asking you, is the mall also on the hook for the joint tortfeasor?
In preparing for this argument today, I ran through a bunch of hypothetical situations, many of which are very close to what you just presented. The question in my mind is, can the owner of the property who has a non-delegable duty, can that owner be liable for any negligence that goes on the premises? Well, first you have to answer the question, do they have notice? You said that the drink was thrown in front of your employees.
So assume every fact that I just told you.
So you've got notice, so we're past that potential problem, and that's one of the issues that...
I have tried to write out every single thing other than the issue that you have raised, which is the mall owner, the owner, responsible for the joint tortfeasor's actions?
If it is that fast as you present
It is.
I would say no.
Okay.
On the other hand, if your employee saw that drink go on the floor and said to the prankster, you need to come clean this up, and the prankster says, I apologize, I'm going to come clean it up, I'll be right back. Doesn't come back, and your employee knows the prankster,
Right.
calls him up the next morning and says, hey, look, you haven't come back to clean this. You need to do that. Yeah, I'll do that. I swear I'm going to be there. And if that you're an owner of the property and your employee knows that this is going on, you're relying on, his knowledge is imputed to you as the employer. You know that you're relying on this guy to come back and clean this up.
Well,
so once you start relying on it, The cases have...
Okay, so let's back up a little bit, and I understand the distinction you're trying to draw. So let's put it to this case. The Shakars have a party at their house. They invite a woman over to their house, and in the course of that, they do two things, and I know there's a notice issue regarding the pleadings, but that aside for the moment. They do two things that are potentially or allegedly negligent. One is they fail to warn their guest of gaps in the deck in which the person falls through, and the other thing is they remove at least for their portion of the backyard or the back area, the orange, what do you call the
snow fence,
snowflake
mesh,
fence,
whatever.
the mesh fence. We actually have one where our court is right now, so we're very familiar with it. The mesh fence that's there. Why are they not joint tortfeasors for that night with whatever negligence KMAC and the non-delegable duty that KMAC has and the association has to make sure its property is clear?
I would say that they are joint tortfeasors, but that doesn't have any impact on the non-delegable duty of Beach Club.
Okay, so how is that the case? Because I have to tell you, I get where you're arguing. I get your point with regard to KMAC. It's an independent contractor who they're contracting with to make sure that the area is as it's supposed to be. I understand that intellectually. I have a harder time, and you're going to have to convince me, and I'm only speaking for myself, where there's a joint tortfeasor that has independent tort responsibilities, duties, and liabilities from the association, and how the association is somehow responsible for that in the same way that the mall is not responsible for the 3 minutes the punk kid threw the coke on the floor.
I have been frustrated trying to find the cases that take it beyond the hiring of that independent contractor. There is language in some of the cases that suggest it, and I'm here to say that there is no substantive difference in my mind. In fact, if you're going to rely on somebody...
Isn't the substantive difference? So by the way, I have not found a case directly on point regarding the question I have. There are lots of cases, not lots, but there are some on the independent contractor's responsibility and liability. And again, I'm having less trouble with that. But isn't the substantive difference that it is a joint tortfeasor with separate causation for the injuries, with separate individual duties to that individual, to the plaintiff, and with separate liability stemming from it?
In my mind, there is absolutely no difference in the duty and who owes the duty to the injured party on the premises between the contractor who was hired as a formal contract and those people on which the owner of the property, the Beach Club Condominium here, is relying on to make sure that people are warned and that the orange mesh fence is up. They're all joint tortfeasors.
So well, I don't know that that's true because the duties that KMAC has stem from and are not necessarily independent of the association, but I at least understand those two. But what we're talking about is a separate third party who is somehow independently responsible for the same exact injury. In other words, an intervening or subsequent cause or a concurrent cause to the same exact injury.
My hypothetical that I dreamt up was involving our dock in our condominium association. A neighbor down the way on the canal has a sport fishing boat, and he routinely takes out people from our condominium to go sport fishing on Saturday morning. He uses their dock, he comes back in, and it's in good repair. He comes back in one day and slams in the dock and breaks it and creates the gaping hole that Ms. Walters fell into. Nice guy, he's around, he tells the owners of the condominium or the board, I'll take care of it, I'm going to get a contractor out here first thing in the morning, I'll do it, and so forth. Once the condominium association starts to rely on someone else, and that's the language that I pick up in, for example, the Pembroke Lakes Mall.
And by the way, Pembroke Lakes Mall is where I get the hypothetical from. The only thing I did there is I added the kid.
But they say if you're relying on others. That's the phrase they use.
But here's the issue. Where's the reliance on the Shakars? Where's the evidence of reliance on the Shakars? Because I understand the reliance on KMAC. I'm having trouble. The Shakars had a party at their house,
okay,
and that's where the injury stemmed from with regard to Ms. Walters for them.
The duty that the Beach Club condominium has is to maintain the property, correct the holes in the dock that were there. They didn't do that. To put up some kind of barrier to prevent access.
It's to correct known problems
and to warn. So they're not doing that. There was no evidence of any signs that were put up to warn anybody. There were no barricades that don't go beyond this point. So who are they relying on to make sure that the owners, when they take down, they know that it's going on. Everybody's taking down the orange mesh fence to get on the dock to go to their boat. They know that's happening. And so who's going to put it back up? At the point in time when ZMAX was there doing their construction work, the employees of ZMAX were doing that. But after that, for that 4-month period,
That's a very good argument for council. That's a very good argument for why the association and KMAC are responsible. I'm still having a hard time as to why the Shakars, who simply had a party on one night and invited someone to their house and didn't tell them and took down their portion of the fence, are not independently responsible for their injuries.
well, we moved for a directed verdict on it. I don't think they were negligent at all, but obviously the judge got past that point, so we went to the jury on that. And they got hit with a very large percentage of negligence.
I'll tell you what, I'm done with my questions, counsel, so I don't know if anyone else has any questions, but I know you need to hear from your opposing counsel.
Okay.
Thank you, Mr. Tillman. We'll give you 2 minutes remaining for a rebuttal.
Thank you very much.
Good morning, Catherine Ender from Colstock Hussein here on behalf of the condominium. Judge, the question that you posed regarding the Shakars' negligence is exactly what we're arguing here. The plaintiff is attempting to impose several separate duties upon the condo. They're trying to impose a separate duty that ZMAX had, that they've alleged from the beginning of the litigation, that they had control, that they created.
But let's say I agree with you that ZMAC doesn't have separate duties. But ZMAC is an independent contractor that's fulfilling some of the responsibilities that, it sure seems to me at least, that the condo association has. In the same way that in Pembroke Lakes Mall, the janitor is fulfilling responsibilities that are owned by the owner of the mall. So why would they not be held? Why are at least those two not jointly and separately responsible? Now, at the end of the day, I think that doesn't help your opposing counsel much because it doesn't get them the $35,000. So I understand why you may get up here and concede on the KMAC, argue on the Shakars, and still end up winning at the end of the day for yourself.
I completely agree with that, Your Honor. Although to distinguish the point and why ZMAX has separate liability, in this case, it's not simply an argument that ZMAX was responsible under its duties as a general contractor or a contractor. What the plaintiff argued from the inception of this litigation is that ZMAX had a separate non-delegable duty. And that was in the complaint. It's record, it begins at record 61. And
it's paragraph 11. At all times, defendant ZMAC
yes.
owed plaintiff non-delegable duties.
Exactly, Your Honor. So they've alleged since day one that ZMAX had a separate independent non-delegable duty, and Florida law specifically applies in that instance to say that parties can have separate independent duties. It's not simply that one party
There's no doubt that's true, but this is the fixing of a dock. The dock is clearly a common element, and the condo association clearly has responsibility there. ZMAC was done to fix it and to make sure it was cordoned off for there. That's their responsibility. What independent thing do they have outside of what was responsible? But let's say ZMAC was never hired. Wouldn't the condo association have to do the exact same thing that ZMAC was doing?
Or hire somebody else.
Sure, hire another independent contractor, but how is that different from a mall that hires a janitorial service as opposed to having on an employee of their own that they have to pay Social Security on
Or
and
here,
Medicare?
I would assume that
That
the condo association had a maintenance person on property who did, work during the day maintaining the common elements.
I understand that, Your Honor.
I mean, I don't know if that's the case, but normally condo associations do have someone who's a maintenance person who would be out there making sure that the orange mesh is in place.
Sure,
So that someone doesn't go out there.
And I don't necessarily disagree with that, but there was a motion for summary judgment that ZMAX filed in this case. Judge Arzola denied that motion for summary judgment. It was on the issue of control and this non-delegable duty. And so there were two separate duties that went to the jury. It wasn't something that the plaintiff, it's not our job to educate the plaintiff on how to litigate the case, and he litigated it as a separate non-delegable duty. So in this instance, when we went into trial, it was two separate duties. There was nothing that
I'm having trouble. I have yet to hear from you what that independent duty is. They list a million duties. They list a million breaches in there. Duty really is a legal issue. I know that y'all argue over that a little bit, but it's really a legal issue for the court to decide as a matter of law. What you're talking about is different breaches of that duty that are alleged here. And I'm having trouble seeing what breach would go to an independent duty that ZMAC had that wasn't owed separate and apart from being an independent contractor by the condo association.
I
It's
can't
hard to
answer that right now. No, it's okay. I would be happy to file some supplemental briefing on
You don't
that
need
if
to
it
file
was
anything?
necessary, but
I've thought a lot about it, it's hard to articulate.
it is hard to articulate. And I know that in the contract agreement, there is a provision that they would provide for security of the premises, and it's not a delegation of our non-delegable duty, but it is a separate duty that they undertook. And so if ZMAX is out there and they have control of the premise and that actual area where they're undertaking, bottom line, it comes down to the duty of reasonable care. And a non-delegable duty stems from this duty of reasonable care to maintain the premises because you either, one, control the premises, or two, have created the condition. And in this case, yes, the condo association is not denying that it has a non-delegable duty to maintain its premises, but ZMAX went out there, and what the argument is in this case, and what the facts alleged in this case, were that ZMAX, the general contractor, went out there and had some sort of duty or had control over that portion of the premises at least, at a minimum, and also that they created the condition by putting up the barrier.
But this is where the case law talks about this. We're not talking about liability. They clearly are liable. No one's saying they're off the hook. That's separate and apart from whether they're jointly and severably liable for the ultimate damages here. That's the real question. So no one is saying that they shouldn't have been on the verdict form, at least no one on this panel is saying that. And no one is saying that they shouldn't be held liable. What we're saying is, at the ultimate on the hook, there's nothing independent that ZMAC had to do that the condo association itself didn't have to do. The condo association would have to make sure that no one goes in the area, would have to fix it, that the place is secure. Those are all obligations stemming from the condo association and its control over common elements.
And I appreciate that, but Your Honor, it's also still, I believe, a separate issue of control. And the way it was pled in this case was as though it was a separate non-delegable duty. And so in this case, the plaintiff presented it as though it was a non-delegable duty. It was a separate allegation of control. It was a separate allegation of creation of this condition where it arose a duty to warn. And so our position was that there were two separate independent non-delegable duties at play in this litigation, and that's why they both went back to the jury. That's why it was apportioned in that manner, and that's why we, the condo association, is only responsible for the 15% liability that was imposed upon us. There's nothing that would suggest that any of the laundry list of duties that were arguably breached in the plaintiff's complaint are segregated out to know whether or not that was the non-delegable duty that they're attempting to impose on the condo association or the non-delegable duty that they're attempting to impose on CMAX, because they did plead it as two separate duties. So that was our position on that point, Your Honor. I appreciate that a non-delegable duty extends to the entire premises, but in this circumstances and under these facts, the plaintiff has created arguably what creates a second non-delegable duty, and that's what was proposed throughout the litigation.
You just can't just allege a duty, though. What evidence was there that they had an independent obligation? Just one piece of evidence.
Well, Your Honor, the plaintiff throughout and the Shakars and the construction, Mr. Robinson, they all testified that ZMAX was under some level of control of that area, and that ZMAX was the one that put up the orange barriers.
But those are things that the condo association would have had to do if ZMAX was not there. In other words, the condo association had the same obligations.
I don't disagree.
Right, okay. That's all that I have.
If no one has any further questions, we would request that you affirm the final judgment in favor of the association on all grounds.
Thank you.
I'm going to try to finish up the thought about the duty on the part of somebody who's not an independent contractor. Say you're an apartment building owner, and instead of hiring a maintenance company to take care of debris around and to make sure the walkways are in good condition, you rely on the tenants. It saves you a lot of money. And you tell the person in this apartment, well, you got to sweep out here, and the next guy, you got to sweep out there. No official contractor. You're telling them what they have to do, and they don't do it. You, as the apartment owner, are liable for that condition. And as the Armature case has pointed out, that's direct negligence. That's not a vicarious liability type of negligence. You have that duty to maintain. It's non-delegable. It's somebody that you rely upon, not necessarily hire, but you rely upon to do this, doesn't do it well, and causes somebody to fall. You're on the hook.
And that answers the question on ZMAC to me perfectly, which is why I tend to agree with your position on them. I'm having a harder time with the random joint tortfeasor who also has an independent cause and responsibility for the injury.
I'd like to make one more point on this and make another comment before I leave. If you look at the public policy behind holding a property owner to a non-delegable duty, does it make any sense to say, well, if you hire the best contractor in town, the most competent people to maintain your property, you're on the hook for their negligence, even though everybody makes mistakes. But if you rely on these people over here, your tenant in the apartment building, the Shakars in our case, you rely over here, you're going to let the property owner off the hook for failing to maintain that property or failing to warn because they took some shortcut. And they rely on somebody that was not the official professional person that they really needed to hire. And that's what's going on here. Every one of these 56 units had a property owner, and virtually all of them were taking down the mesh fence. Well, what does that mean? That means the beach club was relying upon all of these owners to make sure that fence was back up at the end of the evening, to warn anybody that might be their guest, anybody they see out there. This is a board of directors. They didn't have an employee. They used to have a maintenance company before this incident, but they didn't at the time Ms. Walters fell. And so they're relying on, the only person they can rely on are the property owners, the unit owners, and that's what they were doing. Testimony in our case with regard to the failure to warn was de minimis. We weren't worried about the failure to warn argument at all. Testimony was that Ms. Shakar gave a warning. Plaintiff said she didn't hear it, but does that result in 50% comparative negligence? Negligence on the part of the Shakars? Because she testified that she warned people? No, it's because of the taking down of the fence, which is why we objected strenuously all throughout the trial about allowing the defendants to take this, their fabricated offense and add this new theory of liability. Would we have done something different? Absolutely. And I've cited the Goshen case to the court. It was my case. I'm kind of intimately familiar with it. But you can't come in on the day of trial and say, you know what, we're going to amend our fabricated offense and we're going to start making other accusations. We would have asked this jury to consider and ask a verdict question on whether or not Mr. Shakar was the agent. If we knew that that was going to be argued, we would have asked if Mr. Shakar was the agent of Beach Club. He was getting permits pulled. He was getting bids for this project. He was acting on behalf as the agent. But that wasn't an issue coming up to trial until we got there the first morning. It's too late to do anything about it. So if the court can't see extending that non-delegable duty to those people who shouldn't be relied upon to take care of the duty that the property owner has, then we ask that we be given a new trial. Obviously, there was prejudice, and the allocation of percentages of fault here just made absolutely no sense. So we're asked for a brand new trial on all issues if you don't extend the non-delegable duty to all three of the two federals and the other defendants. Thank you very much.
Thank you to both. Have a great day. All rise.